Imagine watching the love of your life slip away, not because help wasn't available, but because a doctor chose their personal beliefs over saving a life. Sounds unbelievable, right? For some families in Nigeria, this is a tragic reality. Welcome! Today we dive into one of the most troubling ethical and legal dilemmas in Nigeria's healthcare system. When religious beliefs collide with the medical professional's legal duty of care, whose rights prevail? And who bears the cost when life is lost? I'm sure many of us have heard some truly disturbing stories from Nigeria's health sector. Stories of patients who walked into hospitals with hope only to leave with heartbreak, or even worse, from poorly trained personnel to broken infrastructure. The truth is hard to ignore. Medical negligence is quietly stealing lives and destroying families. Every day, Nigerians are subjected to substandard care that doesn't just disappoint, but fails disastrously. Yet, despite the growing number of victims, very few take the step to file formal complaints, let alone lawsuits. Why? Is it fear? Is it ignorance? Or is it just a loss of faith in the system? But today, we are looking at a case so alarming, so grossly negligent, it demands a louder conversation. But first things first, what exactly is medical negligence? Let's break it down. Medical negligence is a type of civil wrong. In law, we call it a tort. It happens when a healthcare provider, by action or omission, fails to provide the level of care a reasonably competent professional would offer in the same situation, thereby causing harm or death to a patient. In simple terms, it's when your doctor drops the ball and you suffer for it. Section 14, subsection 2b of the Constitution of the Federal Republic of Nigeria, 1999 as amended, provides that the security and welfare of the people shall be the primary purpose of government. Healthcare is central to this. Strengthening this further, Section 33 of the Constitution provides that every person has a right to life and no one shall be deprived intentionally of his life. Moreover, the legal standard for negligence is set by what a reasonable medical professional should do in similar circumstances. If a practitioner fails to act in that way and harm results, they must be held liable. Some examples of medical negligence include 1. A doctor delays urgent attention to a patient who clearly needs help. That's negligence. 2. Misdiagnosing a condition due to poor assessment. That's negligence. 3. Giving the wrong advice or no advice at all. You guessed it, that's someone's life, you can't do that. 4. Failing to refer a patient to a specialist when it's obviously necessary. 5. Not getting a patient's consent before a procedure, still negligence. And 6. Like the case in question, where a doctor had a clear duty to perform a life-saving procedure but refused, all because of religious beliefs. A life was at stake, but convictions overruled care. Tragic, unacceptable, and sadly, the list goes on. This isn't just bad practice. In legal terms, it's an actionable wrong. It's a breach of duty that causes real harm. And the law says, if you can prove it, you can claim compensation. So, why aren't more people speaking up? Why aren't more victims taking legal actions? Well, maybe because they haven't seen just how bad it can get. But today, we will. Because the case we're about to unpack isn't just a lapse in judgment. It's a jaw-dropping display of reckless disregard for human life and a total betrayal of professional duty. Buckle up. By now, you probably heard some disturbing story that took place on 1st of May at Standard Maternity Clinic in Port Harcourt. A pregnant woman identified as Victoria Paris died after childbirth at a clinic in Port Harcourt, Standard Maternity Hospital, Borikiri. Paris, a mother of 4 and resident of Port Harcourt, was 7 months pregnant when she went into preterm labor. According to her brother-in-law, Chris Adam, she was rushed to the hospital where she underwent cesarean section. The operation was reportedly successful, but Victoria suffered severe blood loss and needed a transfusion. But the doctor, a Jehovah's Witness, refused. Not because blood was unavailable, but because her religious belief forbade it. The incident sparked public concerns over the hospital's policies and the ethical implications of refusing life-saving treatment on religious grounds. The brother-in-law to the deceased wrote, "First, you forget your religion before running a hospital. My beloved was killed by the doctor's belief. In his words, we lost our beloved to the cold hands of death. My beloved was 7 months pregnant and started feeling pains in her stomach. She was rushed to the Standard Maternity Clinic here in Port Harcourt at Borikiri Church Hill. To be honest, it was at this hospital she gave birth to her other children. But this case was different. She gave birth through CS, operation. The doctor ran an operation on her which was successful. But my beloved lost a lot of blood and needed blood to support her life. But the doctor says she doesn't do that in the hospital because she's is a religious person. First, you forget your religion before running a hospital. Second, you ran an operation in your hospital with NEPA lights, which failed during the operation before they started running to put on the generator. My beloved was killed by the doctor's religious belief. The family was strict to sign for the operation because of their selfish interest. Victoria Paris, we miss you. I need justice for my beloved. Today, we are not just here to talk about the problem. We are here to understand the law, the rights of victims, and the responsibilities of medical professionals. Because when we understand the law, we are better equipped to demand better care and justice when care fails. Let's dive in. Whose belief is protected? Doctor or patient? While Section 38 of the Constitution guarantees freedom of thought, conscience, and religion, it does not license a professional, especially one entrusted with life, to allow personal belief override legal duties. Part A of the Code of Medical Ethics in Nigeria, particularly Clause 2B, which provides for the physician's oath, stating as follows: I will not permit consideration of religion, nationality, race, party politics, or social standing to intervene between my duty and my patient. According to Section 33, subsection 1 of the Constitution provides, no one shall be intentionally deprived the right to life except in circumstances provided within the section, which the instant care falls short of. Consequently, it can be inferred that the medical practitioner in this case breached the provisions of the Constitution, as well as the Code of Medical Ethics in Nigeria, of which she is supposedly bound. Clause 30 of the Code of Medical Ethics in Nigeria provides for the punishment in such cases. Where the extent of the negligence has been such that it resulted in permanent disability or death of the patient, then the practitioner will be guilty of gross negligence and be liable to 1. Suspension for a period of 6 months, 2. Having his name struck out of the medical or dental register, as the case may be. What's more, if this matter is brought before a court of competent jurisdiction, and the evidence clearly provides that the practitioner's negligence directly resulted in the loss of life, then this goes beyond more professional misconduct. The doctor could very well face criminal liability, including a conviction for manslaughter or even murder under the law. Would it be different if the patient was the one who made the call due to their own religious convictions? Courts generally respect patients' autonomy, that is, the right to refuse treatment. But when the patient is unconscious or cannot give consent, the doctrine of necessity applies. In emergencies, doctors are legally empowered to act in the best interest of saving life. Where doctors act or fail to act in defense of that obligation, courts may interpret it as a criminal negligence or manslaughter under Section 303 to Section 305 of the Criminal Code Act. Now, what are the consequences of silence? While lawsuits are rare, despite countless tragedies like Victoria's, formal lawsuits for medical negligence in Nigeria remain alarmingly low. Why? 1. Ignorance of the law. 2. High legal costs and protracted litigations. 3. Social fear, especially where the hospital or its owner has influence, power, and money. And 4. Culture or silence. To protect another Victoria, here is what needs to happen. 1. Strict policy guidance. All medical facilities must declare and document whether religious policies influence emergency care. 2. Mandatory referrals. If a doctor's faith impedes treatment, they must step aside. No excuses. 3. Government oversight. Accreditation should require full emergency readiness. Electricity failures during surgery, like in Victoria's case, must become legally actionable. 4. Enlightenment campaigns. Public sensitization on patient rights as enriched in Chapter 2 of the Constitution should be whispered. 5. Legal support system. Government or civil societies must fund accessible legal redress for victims of medical negligence. Whose belief should decide? Life is sacred, religion is personal, but medical duty is professional and legal. If your beliefs disqualify you from performing life-saving duties, you do not belong in the operating room. Justice for Victoria isn't just about one woman. It's a call to prevent every Nigerian from preventable tragedy. Have you or someone you know been a victim of medical negligence? Speak up, know your rights, and demand accountability. If you found this video helpful, make sure you hit the like button and also subscribe to our channel for more content like this. This is Legal Essentials, Ekemudo, signing off.